The Baker Act, navigating life post-72-hour hold. A 72-hour hold may be over, but its impact lingers. So what happens next? How does it affect your privacy, work, and recovery? Let's dive in and explore the ins and outs of this complex issue. The Baker Act is an involuntary medical evaluation, a civil process, and not a criminal matter. Yet, its implications can be far-reaching. From court orders to workplace rules, understanding these intricacies is crucial, but here's where it gets controversial. Can your employer find out about your Baker Act hold? And if so, could it cost you your job? Let's start with the good news. The Baker Act is protected by confidentiality laws. Your medical records are safe, and your employer can't access them without your consent or a court order. Judges only grant access for valid reasons, carefully weighing the need for information against potential harm. As for court records, they are exempt from Florida's public records law, so your personal details won't be easily accessible online. Now, on to the tricky part. Can you be fired after a Baker Act hold? The answer is not straightforward. While the Americans with Disabilities Act, ADA, protects individuals with disabilities, including many mental health conditions, from discrimination, there are exceptions. You can be terminated if you violate workplace rules, have unexplained absences or tardiness, or fail to meet job expectations. However, if you disclose your condition and request reasonable accommodations, such as time off for therapy, your employer is legally obligated to provide them, unless it causes undue hardship. And this is the part most people miss. The Baker Act won't show up on standard criminal background checks, but it may appear on specialized checks for certain professions or government security clearances. For example, if you're applying for jobs in law, medicine, or teaching, you may be asked about your mental health history, including involuntary commitments. Lying on these applications can have serious consequences, including denial of employment and even criminal penalties. As for firearms, a routine 72-hour Baker Act evaluation doesn't prohibit you from purchasing a firearm or obtaining a concealed weapon license. However, if a judge orders further involuntary placement or commitment after the initial hold, those court orders are reported to databases that can block gun purchases and lead to license denial or revocation. So, what can you expect after a Baker Act hold? It's a delicate balance between privacy, job security, and recovery. Understanding your rights and the potential implications is crucial. What are your thoughts on this complex issue? Feel free to share your experiences and insights in the comments below. Let's spark a conversation and learn from each other.